So good morning. Well, it's right at noon, so good noon. How's everybody doing? All right, we're in the home stretch. But what I've got to talk to you about is really important, so stick with me for a few more minutes. As he said, my name is Robin Merrell, and I'm managing attorney at Pisgah Legal Services. I'm a native of Western North Carolina, and I'm proud to say that I am the daughter of a Marine veteran. And that's right, Semper Fi. And it is truly my honor to be in the room with you all today. And I'm very thankful, Mr. Percal, for the opportunity to share this information with you. So first, I'm going to tell you just a little bit about Pisgah Legal Services, where I work. We provide free civil legal services in Western North Carolina. And so that's in a realm of quite a few things: domestic violence prevention, homelessness prevention. What that really means is that we defend people being evicted. Foreclosure prevention, that one's pretty self-explanatory. Access to public benefits. What that means is that sometimes we help people get Medicaid, Social Security disability, food stamps. We can also help if you've got a denial of your VA benefits and other avenues have not been able to help you work that out. Debtors' rights. A lot of people don't know that sometimes the way creditors treat them isn't really okay. Immigration and advance directives, which is kind of a category of things that you've been hearing about today. What we don't do anything criminally related, and that's because you have the right to a court-appointed attorney under the Constitution. We don't do personal injury cases. There's always an attorney out there ready to take your personal injury case. Also, workers' compensation. We don't actually probate the wills. We do help people prepare wills, but we don't go through the process of probating it or really doing the things it says to do. And we don't do medical malpractice. We serve, and this is actually just a little bit outdated as we've recently taken on 2 new counties, but we serve now 8 counties in Western North Carolina: Buncombe, Henderson, Madison, Polk, Rutherford, Transylvania, and now Mitchell and Yancey counties. We do have an income requirement because our services are free. Don't worry about what that is. If you want to seek services from us, you call us and we'll work that out. We want someone to have a qualifying legal issue since we are legal aid. We kind of focus on the basic needs that people have. And then it needs to not be a conflict of interest. And that's just a requirement that the state puts on us as attorneys. So, yeah, I like to say that lawyers are ruining the world for the rest of us. Which is kind of a joke and kind of not a joke. So I am a lawyer, but my presentation today does not make me your lawyer. Does not create an attorney-client relationship. And I'm only going to give general information today and not really specific legal advice. And then it depends. Isn't that the answer lawyers always give? Well, it depends. Sometimes it does depend. So today we're going to talk about the North Carolina law on wills and intestate succession. So I think most people know what a will is. That's a document where you write what you want to have happen to your stuff. Intestate succession is what happens when you don't have one of those wills. And we'll go into some detail about then what does happen. You've heard other things this morning about healthcare powers of attorney and living wills. And we'll just emphasize those again. We'll answer the question of whether or not you need a will, and then the required elements of a will. And then at the end, I'll take your questions. So, I think a lot of what you've heard this morning is about the importance of planning ahead. And I will say that as someone who has been on the other side, having had family members pass away who did not tell us what they wanted, it leaves the family in a lot of confusion. There can be hurt feelings. We all think, my family loves each other. They're all going to get along when so-and-so dies. And then so-and-so dies, and people you never thought would fight. And they're fighting over the china or the earrings or the tablecloth. And that sort of thing, it doesn't discriminate. This doesn't just happen to other families. I've seen it in my own family, and I don't wish it on anyone. So I highly encourage you to think about planning ahead. Now, the more serious side of planning ahead is that you get to say not only what happens to your things, but what happens to your body. A will is a great place to say, I want to be cremated, or I want to be buried at the State Veterans Cemetery or somewhere else. It's just another place to get that in writing. And then once it's in your will, the person who executes your will, called the executor, they have to do it or they get in trouble with the court. So they don't get to decide, well, Granny said she wanted to be cremated, but I don't think so. They don't get to do that. So it's a place to really be solid about what you want and be confident that your wishes are going to be known to those acting on your behalf. So, you've already heard this morning, the documents everybody should have: the durable power of attorney, your health care power of attorney, your living will. And those are mostly going to come into play when you're incapacitated. But as the gentleman before me was talking about, we don't know when things are going to happen. They often happen as a surprise. And I will say that one of the things that I really like about having a durable power of attorney is that if you later become incapacitated, your family does not have to go through a court process to become your guardian. That is a long and cumbersome process, and it leaves people kind of hanging out there in limbo while the guardianship process is going through. But we're really here to talk about wills, aren't we? So incapacitated, that's a big fancy term, and it really just means that you can't make your own decisions anymore and that you can't communicate those decisions. So the will is the legal document that allows you to control how and to whom certain assets owned by you pass at your death. In other words, what happens to your stuff. So whether you have a will or not, your estate, your holdings, your belongings at your death, they're still subject to claims by creditors, your taxes, the cost of administering or executing your will, and other lawful claims. So what does that really mean? It means that things like your taxes and your burial expenses are going to be paid before your children or someone else is going to get any money or any property. There are some extra protections for surviving spouses, and we're going to talk about that in a minute. So, what happens when you don't make a will? And even just this morning, being out at the table talking to folks, someone said, well, the state gets it. Well, that's not necessarily true. But there are a complex set of laws that determine who gets your property. And if without a will, without naming a person to take care of things, then the court will appoint someone. And this might be someone you're close to could go and apply, but short of that, then it's going to be really a stranger. It's going to be the public administrator. And without the will, there's no guardianship provided. So don't worry about trying to read this. I'm going to go through each one of these scenarios, and also there are pages outside with all of this information listed. But as we're going through them and you hear your situation, if you want to make a note, make a note. But these are the different scenarios of what happens when you die without a will and who gets your stuff. So the first one is if you are not married, you do not have children, but you have parents who are alive. And in that instance, it is divided equally between your parents. If you only have one parent living, so this is my circumstance, I am not married, I do not have children, my father is deceased, my mother is alive. That means that she would get everything that I have if I die without a will. So then we have, you're married, your spouse is alive, and your parents are alive, but you have no children. And this is where it gets kind of counterintuitive. It's not necessarily common sense, and it gets a little more complicated. So your spouse is going to get the first $50,000 of your personal property, and then half of the remaining personal property and half of your real estate. So say that you've got $100,000 in the bank, you have living parents and a living wife, and your wife's name is not on your bank account. She gets $50,000, then she gets $25,000, but $25,000 goes to your parents. So if that's not what you want, that's when you need to have a will. It also means that if you own a tract of land that's just in your name and not in your and your wife's name, then she's only going to get half of it. And then your parents are going to get the other half. Now, if the property is titled to you and your wife together as a married couple, it all goes to her. But that's where this kind of gets a little tricky. All right, so you have a spouse, but you have no children, and your parents are deceased. Well, then your spouse gets it all. So that one's pretty simple. So, but say you've got a spouse and a child, and this can be an adult child. It can also be a disabled child or an incapacitated child. And did I say it can be an adult child? So for like this instance, I'm a child, even though I'm 44 years old. So your spouse is going to get the first $30,000 personal property, and then half of the remaining personal property and half of the real estate. And the kid gets half of the remaining personal property and half of the real estate. So once again, if you're okay with that scenario, you don't have to make a will. But if you want something different, you would need to. So spouse and 2 more children are alive. So this was the circumstance when my father passed away. And he passed away without a will. He also passed away without much. So we didn't quite get to these numbers. But the spouse receives the first $30,000. Then 1/3 of the remaining property and 1/3 of the real estate. The children get the 2/3 of the personal property and the real estate to split between them. Then, if you have 1 or more children alive but no spouse, then your property is divided equally between your children. And what if you're alone? You have no spouse, you have no children, and your parents are also deceased. Well, if you've got a third cousin somewhere, then that third cousin's going to inherit. In the event that you have no remote relatives or they can't find them, then that's when your assets pass to the state of North Carolina. Now, I will say, and I did not go into the details of this for this presentation, but if you have grandchildren who are the children of your child who is deceased. So this happened in my family. My father passed away before his mother did. So there are rules depending on the language you use in a will that can allow grandchildren to inherit. That gets more complicated if you've got that situation where you have living grandchildren but a deceased child. I highly recommend you speak to an attorney about the way to structure your will. So an attested will, that's what we think of as the official will. That's the one that's all typed out on pretty paper and a notary notarizes the signatures. So who can make one? Any person of sound mind, 18 years or older. They need to have 2 competent and disinterested witnesses. So disinterested means someone who is not related to them, and someone who's not going to inherit under the will. The person making the will and the witnesses must sign. Those signatures will be notarized. And there is special language that can be added that makes it a self-proving will. That's important for probate, because if it's not a self-proving will, the executor has to go find those witnesses and make them swear that that's their signature. If it's a self-proving will, they don't have to do that. But now let's just say that you don't have time to go to the lawyer. You don't have the money to go to the lawyer. You don't want to go to the lawyer. You can actually draft your own will in North Carolina, and that is legal. But it has to meet certain requirements. And it's called a holographic will. And I don't really know what holographic means. It sounds a little see-through or ghostly. But there's some requirements. Once again, you got to be 18. You have to write it yourself. It needs to be in your handwriting. You can't have your sister write it for you. You got to sign your name on it, anywhere on it. Doesn't have to be at the bottom. You have to put it in a safe place. And that's a safe place is defined by you. I frequently tell people, put it with your other important papers. And there's not a requirement for a witness. There's also not a requirement for a date. While this is perfectly legal, I do not recommend it. It is just too easy to lose it, for your family not to find it when you die, for someone to come along and say, oh, no, here's this new one that Granny made. And, you know, it might be or it might not be. So while this is legal and you can do it, and honestly, this is what I had before I got an attested will, I just don't recommend it. So where do you go to get these documents? If you live in our service area and want help from Pisgah Legal Services, please call us and we'll talk to you about that, see if you qualify for us. Also, there's the North Carolina Attorney Referral Service. This is a service where you call the number, you tell them where you live, what kind of attorney you're looking for, and they can give you a list of attorneys in your area who have agreed to do a low-cost initial consultation. And then, what are your questions? And I'm going to let the microphone people.
I have a valid will from another state. Is it recognized in North Carolina?
Where are you? Oh, good. I like to look at people when I'm talking to them. So there is a clause in the United States Constitution called full faith and credit. So if your will is valid under the law in the state it was written in, North Carolina has to recognize it.
Thank you. A second quick question. Could you give us a little more information on what makes a self-proving will self-proving?
It's the language in the will. I forget the exact words, but it's a sentence that's included, and it has to have the notarization of all the signatures.
Regarding competency, that is a huge issue because there's legally competent, which is pretty black and white, and then there's medically competent, which is very gray. I deal with a lot of people who have mental health issues and dementia, or one of the each, or both together is the most complicated. So even though they may have a power of attorney with the durable power of attorney and everything seems to be fine on paper, it's often a real negotiation process between the senior who may have dementia or mental health issues, because what they lack often is judgment and insight. And they can have these documents, but the most important thing is for people to have a caring team, family members, someone who's advocating for them, so they can say, well, yeah, we do have this power of attorney, but you're not making good judgments. You're emptying your bank account. You still are legally competent, but you're emptying your bank account. So you need someone, again, an advocate to kind of still help with these documents in place. But the documents are most important as well.
Documents are most important, and I will say that we're all better off when we have a team of people caring for us. But also, I'll just be a little bit of a lawyer for a second and say that we all have the right to make bad decisions. And that, you know, what I tell folks is that until a court has removed someone's competency, they get the right to make bad decisions, unfortunately.
First of all, let me thank you for the presentation. Second is, since wills have to go through probate, and probate not only gets expensive, but also lengthy, is it better to have a will, or is it better to go to a trust?
I'm not qualified to answer that question. I will
Okay.
tell you, though, that personally, in my will, I have set up a trust for my mother should I predecease her, for what that's worth.
I think he preceded my question. In terms of a revocable trust, any advantage to that? I know a will is separate from that, but the two together, is there any advantage? And perhaps you're going to give me the same answer you.
Well, I'm going to tell you that I can't give a detailed answer to that. It's my understanding that there are some tax advantages, and,
To a trust?
yes.
But it also facilitates probate, does it not?
It does facilitate probate and possibly allows a way around some probate.
Okay. Thank you so much.
You're welcome.
Thank you, sir.
My question is, okay, you kept using the term child.
Yes.
Is there a distinction between let's say the person that dies is non-biological or stepchildren involved? Stepchildren and children, are they, and
They
are
are,
they- is it-
they are not the same in the eyes of the law. It needs to either be a biological child or an adopted child. And sorry, I keep going back to my own family for these examples, but my mother already had my brother when she met and married my father. My father adopted my brother, so in the eyes of the law, my brother is as much a child of my father as I am, who is his biological child. But say in this example that he had not adopted my brother would have been a stepchild and would not inherit under this scenario, which is another reason that if you have a close, loving relationship with your stepchildren and you want them to inherit, you need to write it in a will.
May not be a pertinent question, but what is the role of the clerk of court?
That's always a pertinent question. So the clerk of court is charged with the administration of court, basically keeping it running and taking care of the paperwork. And so it's the probate section of the clerk's office that is going to do the probate paperwork. They're going to open the file, they're going to show somebody which documents have to be filled out, they're going to make sure those happen. Then if those documents are not maintained and turned in on schedule, that's who will reach out and say, this is due. The clerk of court gets to act like a judge in certain situations. Probate is one of them, and guardianship is one of them. So if it comes down to there being some sort of question, you can get called in before the clerk for a hearing, and the clerk will make decisions. Those decisions can be appealed to a superior court judge, but the clerk has quite a lot of authority and power in these situations, which clerks are elected, and so those are political positions. I will say that the clerk here in Buncombe County is very professional and runs a professional office. But I also think that it's yet another reason to have a very clear and unequivocal will saying what you want.
Can you protest a will, child protest a will?
You can. It's called a will caveat. And it can be lengthy and expensive. It might be worth it depending on the circumstances, but it can be done.
I have one, actually. If an unmarried couple living together, neither has a will and they own the home together and have joint bank accounts or pay on death accounts, do they need a will? Are they safe from outside intervention if one of them passes away?
For the most part, yes. If the one who passes away owes a large amount of debt to a creditor, then their interest in the home could be at risk.
That's North Carolina state law, correct?
That's North Carolina state law. I think, though, absent that, and as long as they're clear on what each other want in terms of their burials and their funerals, I think it's probably fine. Mhm.
I stay home and take care of my dad full-time, and he's 97 years old. I'm one of the alone people. My husband died years ago. When my dad dies, I no longer will have a parent. I don't have children. I have 5 brothers and sisters. Do I need a will?
Well, under North Carolina law, without a will, your property would pass to your siblings equally. If, then you don't need a will unless you need to communicate something else to them through that will.
Fantastic. And if you do a holographic will, do you file that at the courthouse?
No, a holographic will you don't file at the courthouse. You just keep it with your important papers at your home or your safe deposit box or wherever you keep your important stuff.
I'm going to be calling fiscal legal.
We look forward to it.
Yes, hi. Is Pisgah Legal Services available to Haywood County residents?
No, unfortunately, we are not. In Haywood County, you could call Legal Aid of North Carolina. They have an office in Silva that assists Haywood County, or this North Carolina Attorney Referral Service.
If you have a revocable living trust, do you need to go take that paperwork to probate? You know what I mean? If something happens?
I don't know. I'm sorry.
Okay.
If you purchased property before you were married, and so your spouse's name is not on it, but at your death, does it, in North Carolina, does it already automatically go to the spouse?
No. No, it doesn't. He asked if you bought property prior to being married and you never transferred the title to your spouse's name and you pass away, does it automatically go to your spouse? And the answer is no. If you have a will leaving it to your spouse, it will. Anybody else? You've been a great audience.